All right. Good day, everyone. This is Professor Brenton Boyce. This is Courtroom Testimony, CRJS260. Uh, Tonight or today, I'm going to lecture on the constitutional requirement of confrontation and cross examination. We're going to talk about the hearsay rule. Different types of hearsay. So, you're going to get two lectures on two different cases, and I'm going to post the case. But we're going to be talking about the hearsay rule, a very important rule. We kind of touched a little bit in the book when we talked about not being able to say we or what we did, because you can never speak from the standpoint or talk about what someone else perceived, and you can't say what someone else said generally. So you're only supposed to talk about what you perceived, and we're going to talk about why. Just as a background, of course, the Sixth Amendment of the Constitution is where the confrontation clause is. Essentially, what that means is if someone's going to come to court and testify again, if someone's going to say that you did something, you have a right to go to trial to challenge that, to say, well, if you're saying I did it, then come to court and prove it. As a defendant, it's not even your job. You have no burden of proof. You have no burden of proving that you didn't do it, even though that helps. You don't have to. You don't have the burden. The defendant can just walk into court and sit down and twiddle their thumbs. The only side of the case that has the burden is the prosecution. They have the burden of proving guilt beyond a reasonable doubt. So they have the burden of production as well. That means they have to produce the evidence. They have to get the witnesses that are going to help them enter the evidence. Because remember, evidence doesn't get in without being testified to. So that's their job. So as a Sixth Amendment right, if you're going to say I did something, or you have a witness, or someone said I did something, then my Sixth Amendment right, I have a right to demand that they show up to court at a trial and face me and tell me I did it, and I should have the opportunity to cross examine them, and challenge them to say why, to say this person's lying, or their credibility is shot, or they didn't see it. So that's the Sixth Amendment. That's the confrontation clause in a nutshell. So we're going to talk about this one rule that's actually a rule in the evidence code. The rule is the hearsay rule. We're going to talk about what it is, and we're going to talk about how it applies, and how it is kind of meshed, and the purpose behind it is the Sixth Amendment. And it doesn't even just the hearsay rule doesn't just apply when it's a defendant, asking person to come to court. The hearsay rule applies across the board. So if there's any statement that comes in and the person that made that statement is not there to testify to that statement that's alleged to have been made, then either way it goes, whether it's against the defense, against the prosecution, is generally not allowed in court. So in general, the general rule is hearsay is not admissible in court. That's the general rule. There are certain exceptions. Now, there are a lot of exceptions, and we learn those in law school. We're not going to go through every exception. There's a whole class on evidence in law school, and hearsay is the bulk of the semester. Like, evidence was a class thing in law school. I take that 2 semesters. No, I took it. It was 1 semester, but we were on hearsay and the hearsay rule for a long time. So hearsay is one of the most important rules in evidence. It's relevance, of course, and then hearsay. Now, relevance, of course, the general rule of relevance is that only evidence that is relevant is allowed into court. So when relevant evidence, as definition, is evidence that tends to prove or disprove a material fact or element in the case. So if it doesn't do that, it's not relevant. And so, in other words, it's wasteful and it's wasting our time. Then we have the hearsay. I told you the hearsay rule. There's generally not allowed unless it falls under an exception. So what is hearsay? Hearsay is an out-of-court statement made by a declarant or person that's not there, and is being offered into testimony, and is being offered to prove the truth of what was actually said. Let me explain. If Mary J. Blige is walking down the street and she hears Little Kim say, "Hey, the Crips just killed Biggie. Then now it's time. Now the Crips are on trial. So no, she said Snoop Dogg killed Biggie. So now Snoop Dogg is on trial, and let's say, Little Kim witnessed, Snoop Dogg allegedly killed Biggie, and she said it, and Mary J. Blige heard it. But when it's time doing Snoop Dogg's trial, now all of a sudden Little Kim is nowhere to be found. Probably because the Crips got to her. I don't know. But Little Kim is nowhere to be found. But the only person that heard Little Kim say that was Mary J. Blige. So now it's Snoop Dogg's murder at the murder trial. It's Snoop Dogg's murder trial. The prosecution wants to put Mary J. Blige on the stand to testify to what Little Kim said. So if they're offering that testimony to prove the truth of what Little Kim said, that Snoop Dogg did in fact kill Biggie, then that is hearsay and it is not allowed. Why, you ask? Because the Sixth Amendment. Because remember, Mary J. Blige didn't make the statement. She's coming to court and she's testifying to a statement that someone else made outside of court, and that person isn't here. So remember, there's a Sixth Amendment confrontation clause that says if any statement or testimony is being offered against me, that person has to come to court. So and I have the right to cross-examine it. So if that statement gets in, if that statement that Little Kim made to Mary J. Blige saying that Snoop Dogg killed Biggie is able to come in because through Mary J. Blige, and remember, Little Kim's not there, she's not available. If Mary J. Blige is able to walk into court and say, well, Little Kim told me that she saw Snoop Dogg kill Biggie, then how in the world is Snoop Dogg's defense attorney going to cross-examine Little Kim? Because the person to cross-examine wouldn't be Mary J. Blige because she's not the one with the substantive testimony. So if we have the Sixth Amendment right to confrontation and the right to confront and cross-examine witnesses against us, how on earth are we going to cross-examine that statement that was made by Little Kim? We're not, because Little Kim's not there. And it's unfair to let that statement in because we don't know now. So we don't know if Little Kim really saw it, whether she was joking. Now, the one thing the witness could testify to is how she said it and that she was serious about it. But if it's being offered to prove whether or not Snoop Dogg actually killed Biggie, which is in question, then it's not allowed. Now, so remember, so that means the hearsay rule or the hearsay definition is two-pronged. That means it has two parts. It's an out-of-court statement made by someone that's not there. So that is that. So and the statement, and so when I say statement, it's not just what comes out of a mouth. It can be documents, anything. It's a document prepared by someone. The person that prepared the document isn't here, or whatever. So it's not. So hearsay is not just limited to what people say. Hearsay is also what people write, notes, diaries, stuff like that. That is also hearsay. So those are also out of court statements. When we say those are statements, so those are statements. Now, some of those things, some of these documents, are exceptions to the hearsay rule because depending on what type of document it is, because of the way it's kept, because it's regularly recorded, or is in other words, because of the reliability of the document itself, they allow that to come in as an exception, even though it technically fits the definition of hearsay. But we're not going to talk about the exception. So let's get back on point. So what do we have? So remember, it's out of court statement made by a declarant. That's the first part. The second part is also just as important. So I don't want you to think something's hearsay just because a statement's made and the person that made it isn't there. It's more than that. That is the main part of it. The second part of it is that it's being offered to prove the truth of the matter asserted. So whatever the statement, so it's being offered to prove the truth of what was said. So if what was said in this Snoop Dogg murder trial is that Snoop Dogg killed Biggie, and they're offering Little Kim's statement that was made out of court and she's not available, they're offering it to prove that Snoop Dogg didn't, that what she said Snoop Dogg killed Biggie, If they're offering to prove the truth of what she said, then it is hearsay. So it's two things. It's an out of court statement made by a declarant that's not present in court. Then the second part is that it must be is why it's offered. So it's not just that it's a statement that's made by someone that isn't there, but you also have to question why it's being offered. If it's not being offered to prove the truth of what they said, then it's not hearsay. So it's two-pronged definition. So what's an example of it not being offered to prove the truth in the matter asserted? Let's say we're no longer in the Snoop Dogg murder trial. Let's say we are in the Little Kim. We're in the trial where they're now accusing Suge Knight of killing Little Kim because she was going to be a possible witness in the Snoop Dogg trial. So in this trial, Mary J. Blige is there again to say that, Little Kim, so now the question is when Little Kim was murdered by Suge Knight, supposedly murdered. So if they asked Mary J. Blige, when was the last time you saw Little Kim? And she says, yeah, it was Wednesday, but they're claiming she was dead on Tuesday. But she says, yeah, it was Wednesday. I saw her because she told me that she saw Snoop Dogg kill Biggie. Now, is that an out-of-court statement? Yes. But it's not at this point being offered to prove the truth that, to prove what was being said, that, that Snoop Dogg did in fact kill Biggie, which is what Little Kim said. Now it's being offered to prove that Little Kim was actually alive and not dead. So if Little Kim is able to say something to you, that means she is living. So now in this trial, we're trying to figure out when Little Kim, who killed Little Kim, and when she died. So in this situation now, that statement is being offered not to prove the truth of what Little Kim said, but it's being offered to prove that she said anything at all. So in other words, she was living. So that's different. So in that situation, it is allowed because because in other words, it's not worth cross-examining the statement because you're not trying to prove that it's true anyway. You're just trying to show that it was said. So now the only person to be cross-examined is Mary J. Blige to determine whether or not she in fact saw Little Kim. It's not really about what she said. It's the fact that she was able to be alive and say it. So she was alive and kicking. So that's the difference. So in the Snoop Dogg murder trial, where it's been offered to prove that what was said, that it was being offered to prove that Snoop Dogg killed Biggie, then it's not allowed. It is hearsay by the technical definition. So unless it falls under an exception, and that doesn't, then it's hearsay and it's not allowed. But in the second hypothetical, where it's being offered at a different trial and being offered for a different purpose, and now it's been offered not to prove the truth of what Little Kim said, but it's being offered to prove that Little Kim said it in the first place because she was living, then that's not hearsay in that situation. So to determine what hearsay is two questions, and judges get it wrong. People have been practicing law for years get it wrong. The only reason I really know it now is because I teach. So I gotta reteach it every semester. So it's one thing being an attorney, being a professor and an attorney, and teaching what I do. Makes me sharper at what I do. I'll be knowing the rules. I'm like, I can't believe I knew that. Thought I forgot that in law school. But it's a two-pronged test. It's not just that it's an out-of-court statement made by someone that's not there, but it's also why it's being offered. Is it being offered to prove the truth of that statement? Or is it being offered for some other purpose that has nothing to do with the truth of whether the statement is true or not? So that's hearsay. So you know the definition now. Now that you know that, I've laid the groundwork. Let's talk about the Melendez Diaz case. I think that's first. Yes, the Melendez Diaz case. This is a case. It was argued in 2008, decided in 2009. The full case name is Luis E. Melendez Diaz versus the state of Massachusetts. So Melendez Diaz v. Massachusetts. 2009 is a United States Supreme Court case in which the court held that it was a violation of the Sixth Amendment right of confrontation for a prosecutor to submit a chemical drug test report without the testimony of the person who performed the test. While the court ruled that the then common practice of submitting these reports without testimony was unconstitutional, it also held that so-called notice and demand statutes are constitutional. And we'll talk about what that means, notice and demand. A state would not violate the Constitution through a notice and demand statute by both putting the defendant on notice that the prosecution would submit a chemical drug test report without the testimony of the scientist, and also giving the defendant sufficient time to raise the objection or ask that the person be there because they want to question them. So, background. In 2001, Boston police received information from an informant regarding suspicious activity at a Kmart store. The informant stated that an employee repeatedly received phone calls at work, after which he would leave the store, get into a blue sedan, and return a few minutes later. Police set up surveillance and witnessed this activity occur. Police detained and searched the employee, finding 4 clear plastic bags containing a white powder substance alleged to be cocaine. Police detained and searched the passengers of the blue sedan, including Luis Melendez Diaz. Then transported them to the police headquarters in a police car. During the trip, the police observed the arrestees fidgeting and making furtive movements. Upon arrival at the station, police searched the interior of the police car and found 19 smaller plastic bags containing a white powder, again alleged to be cocaine. In accordance with Massachusetts law, police submitted all alleged contraband for chemical testing. The Melendez Diaz was charged with distribution and drug trafficking of cocaine in an amount between 14 and 28 grams under the Massachusetts Controlled Substances Act, a felony punishable by not less than 3 years imprisonment. At trial, the prosecution placed into evidence the bags seized from the police car. It also submitted 3 certificates of analysis or affidavits showing the results of the forensic analysis performed on samples of the seized white powder. The affidavits reported the weight of the seized bags and claimed the substance found was cocaine. The affidavits were sworn before a notary public in accordance with Massachusetts law. Melendez Diaz objected to their admission, asserting that the Supreme Court decision in Crawford v. Washington, which we'll talk about later, required forensic analysis to testify in person. The trial court overruled the objection and admitted the affidavits as prima facie or first face evidence of the positive presence of narcotics. The jury trial found Melendez Diaz guilty. He appealed, contending that the omission of the affidavits violated his Sixth Amendment right to be confronted by those witnesses who would testify against him. The Massachusetts Appeals Court rejected the claim under the Massachusetts precedent, which held that the omission of these affidavits did not violate the Confrontation Clause. The Supreme Judicial Court of Massachusetts denied review. Melendez Diaz then appealed to the United States Supreme Court. And because this is a major case, regarding the Sixth Amendment right, the Supreme Court said, the Supreme Court of the United States said we will hear it. So they granted what they call a writ of certiorari, and they determined that they would hear the case. It was a groundbreaking case. So the opinion of the court. Justice Scalia delivered the opinion of the court, in which Stevens, Souter, Thomas, and Ginsburg joined. Justice Thomas filed a concurring opinion. Justice Kennedy filed a dissenting opinion, in which Chief Justice Roberts and Breyer and Alito joined. So it's obvious Justice Roberts would want to, I'm sorry, I don't want to give my political opinion, but of course he would want to violate the Sixth Amendment right. The court emphasized that its ruling was a continuation, but little more than an application of its holding in Crawford v. Washington. So essentially what the court said was allowing, so here's what's going on in the case. This guy was charged with possessing narcotics or drugs, allegedly cocaine. When he gets arrested, of course, the cocaine that they have that they seize, it gets seized and it gets sent to the state lab to be tested to confirm whether or not it is in fact cocaine. Once it's tested, the state lab files paperwork that says this is cocaine. They weigh it, how much it is, everything. This is cocaine. It gets time stamped and it is sworn in front of a notary, and it gets sent back to the DA. So what happens is at trial, the DA offers just this piece of paper into evidence. Here you go, judge. This says that it's cocaine. The issue we just talked about hearsay, right? So the paper or the report that the analyst sent back is now tantamount to a statement. Remember, we talked about out of court statement made by a declarant, and that declarant is the analyst that did the testing. And it's being offered to prove the truth of the matter asserted, right? So it's being offered to prove what was in the report. The report says it's cocaine and this is how much it is. So it's being offered to prove that, but the person that actually made the statement is not there to testify to it. Right? That means that Melendez Diaz, he was robbed of his right to now cross-examine this person. And what's crazy in real life, well, this did happen in real life, but there's a current event now. If you guys have watched Netflix, what's the name of that? Let me see if I can find it. I want to find this because it's not that you guys are going to look it up, because you guys ain't going to look it up. But I at least want to give you the opportunity to look something up. Let me see here. It's a Netflix special called "How to Fix a Drug Scandal." How to Fix a Drug Scandal. It's a must-watch on Netflix, especially for attorneys. What's crazy, in the same state, Massachusetts, there was a huge fraud case against one of the main people in the state of Massachusetts, where these drugs were being sent. She was actually falsifying the reports. Actually, she wasn't even testing the stuff. She was looking at it saying, yeah, it's cocaine. And she was lying, saying she did all this testing and stuff like that. And what's crazy, she moved up the ranks because they were like, wow, she tested stuff so fast. She worked so efficiently. Realized she wasn't even testing the stuff. Then there was another lady also in Massachusetts that she was actually dipping into the drug stash. So she was a drug head. So the drugs that would come in, she was supposed to be testing it. She was pocketing it and using it. She was an addict. So now we have an addict on one side of Massachusetts, I think it was the western side, that's now in charge of reporting whether this stuff is dope. And as a matter of fact, she's actually using some of the testing agents, because sometimes they use drugs to test drugs, to test how strong a drug is or whether it is what it is. So and they call those I forgot what they call them. But the standards. So she runs out of standard, so she's using the lab stuff and the stuff that comes in to be tested. And this woman is being relied on to give reports. And now everybody, so not 100% of the cases that came in, everybody had dope, right? So now everybody, everything comes back that is positive. So that's a lady on the west side, but then there was a lady on the eastern side of the state, because they split. They had two labs a lab on each side of the state. This other lady literally is not testing anything, and not only that, she's coming to court and testifying, which is crazy, and saying, yeah, it is what it is. So it is crazy. So that kind of gives a historical significance, because I think that happened a little bit after this case. But still, it's real. So I think a defendant who gets this report in their face talking about this, it is what it is, prima facie case. You had the drugs. It's like, well, who wrote it? I should have the right to cross-examine them. That's my right. I had the Sixth Amendment gives me the right to cross-examine them. If it is dope, they're gonna have to come to court and tell me it is what it is, and we're gonna ask questions about their standards, because that's what you would. Because people think, well, it's a report from the state office, it's got to be real. It's like, no, they make mistakes too. In actuality, of course, there's standard operating procedures for testing drugs, and if you have an expert on your side that knows how to test it and knows what the standard operating procedures are, they can add. You can now ask questions about that. And I don't know if they allow this, but I want to say you might be able to get an independent test to also determine what it is and have your own expert. So, of course, if you're just walking this into court, you don't have that opportunity. So essentially, he was robbed of. So whether or not he was selling drugs or whatever doesn't matter. He was robbed of his right. Um, the court overturned his conviction and sent it back down. And essentially, you see the court's final ruling. So they overturned the case, and of course, it had to be things had to be adjusted. Or I can't remember whether he got a new trial or whether they just dismissed his case altogether. But that the holding out of the case is that was unconstitutional. It was no longer constitutional to send drugs to the state lab, and they send a report back, and that report be good enough, and the person or at least a representative from the office didn't have to come and testify to the standards or testify that it is what it is. To combat that, what they said is, well, we want to put a notice, what they call a notice and demand statute in place that says, well, if our chemical analysts are going to be forced to come to court, we're going to put in that we're going to get what we're going to do is put in notice that the DA has to file something that puts the defendant on notice that we're going to use the chemical analyst report, and then they give the defendant a certain amount of time to respond to say whether or not he wants them to come to trial or not, or whether or not he wants to confront them and have them come to court and testify so he can cross-examine them or not. Now, in that notice and demand statute, if the defendant, once he's served with that notice, if he doesn't respond in a timely manner, I think it was like, 30 days or something like that. It was some type. If he doesn't respond, then he automatically waived the right to now assert his Sixth Amendment and demand that this person come to court. So they they didn't really find a way around it. They still had to give notice and let them know we're gonna just in case you need to know this. We're gonna offer into evidence, or we're gonna present this chemical analysis from the state. So if you want this person to come and testify and you want to challenge them, you got 30 days to let us know. Otherwise, you've waived that right. So that they pretty much put that in to combat the Supreme Court's ruling. So they were still able to do it, but of course, at least now they gave you notice. They didn't just walk into court the day of like, here, there you go. So that is the Melendez Diaz case. So you see how that hearsay evidence in certain situations can also violate constitutional rights. So you see, so it's not just a matter of trial fairness and each side, because sometimes in certain situations hearsay doesn't violate a constitutional right. So if this defendant offering hearsay evidence, it's not going to violate a Sixth Amendment right of the prosecution, because the prosecution doesn't have a Sixth Amendment right in this setting. But they're allowed because of the hearsay rule. But when it's used against a defendant, it's not just the hearsay rule and evidence, but it's also a matter of constitutionality. The defendant having the right to make the people that are accusing him come to court and testify against him. So that is Melendez Diaz case. So groundbreaking case out of 2009. I did so read it for yourself as well. So I posted the brief excerpt and the reading from the case, so you can figure out what the case is about. So that's Melendez Diaz. So study that. I am going to test on what hearsay is. We're going to talk. You might get tested on Melendez Diaz, and the holding from it, and certain hypotheticals. So be ready. So do not ignore this lecture, and do not ignore reading, and do not fail to read the Melendez Diaz case. It's going to be very important. So without further ado, you guys take care, do your work, read, and listen to me. Be good.